In this class, we'll discuss question number 7 of Partnership Act 1932 that we have selected out of the entire syllabus, which are important into the exams of 3-year, 5-year LLB exam. So also those who are having exams in business law or commercial law. So question number 7, what is meant? Why the implied authority of a partner? How and in what manner is such authority restricted by law? So the very answer is that implied authority of a partner, the general authority of a partner as agent of the firm, has been given different names such as implied, ordinary, apparent, and ostensible authority. The authority is founded on the principle of agency. Partners are the partners are the general and accredited agents of partnership and may consequently bind all the other partners by their acts in all matters which are within the scope and objects of the partnership. This authority of a partner to bind all the partners by an act on to carry on in the usual way business of the kind carried on by the firm is called the implied authority. Implied authority flows from legal relation of partnership. The partners may be contract, restrict the implied authority, but third persons are not allowed or affected by such restrictions unless they had notice of it. And in our next question, that is question number 8, we would find the extra and the other portions of the answer of question number 7, and that question number 8 is, can a partner be expelled? If so, when? What are the remedies available to a partner who has been forcibly expelled from the partnership business? And the very appropriate answer to this question, we would analyze the provisions of section 33 of the Partnership Act. So regarding very expulsion of a partner can be expelled from a firm, but the following conditions must be satisfied before expulsion of a partner, and these conditions are: 1. The term of the partnership agreement must confer the power to expel a partner, and the second condition is that the expulsion must be made by a majority of the partners of the firm, and the third condition, decisions of expulsion by the majority must be made in good faith. In other words, the decision must be for the benefit of some partners only, and a reasonable opportunity should be granted to the partner to explain the charge brought against him, and as it is provided under section 33 of Partnership Act 1932, the remedy of this expelled partner is to use of a declaration that the notice of expulsion is void, and that the partner serving the notice be restrained from serving the notice and during the pendency of the suit he should apply to the court to issue a temporary injunction upon partners forbidding them from excluding him from the business. And now we'll go to question number 9, and that question number 9 is, what are the rights and liabilities of an expelled partner, and as it is provided the answers under section 38 subsection 2 of Partnership Act 1932. So the very rights of the expelled partner, an expelled partner is entitled to get the entire amount contributed by him towards capital, and he is also entitled to share the partnership profits up to the date of his expulsion. And the very liabilities are, a partner who is expelled from a firm does not thereby cease to be liable for partnership debts or obligations incurred before his expulsion. The liability itself is discharged or unless there is an agreement between expelled partners, the continue guarantors, and the creditor or the parties, to the effect that all business shall be taken over by the continuing partners, the expelled partner being discharged from them. All expelled partners is liable for debts of the firm incurred subsequent to his expulsion, if public notice of his expulsion has not been given. The liability extends to the torts of the co-partners. The public notice may be given by the expelled partner or by the continuing partner, as it is provided under section 38 subsection 2 of the Act. And now we'll go to question number 10. On what grounds can a partnership be dissolved by court? Explain. So, regarding that, we would like to discuss the very provisions provided under Order 32 Rule 15 of Civil Procedure Code and Order 21 Rule 49 of Civil Procedure Code. So, regarding that, very dissolution by the court, partnership may be dissolved by a court at the suit of partner on any of the following grounds. So those grounds are, the first one, that a partner has become of unsound mind. The insanity of a partner is a ground for the dissolution of a firm by the court, but does not per se cause a dissolution. It requires a suit to be filed by any partner, including the insane partner. So far as the insane partner is concerned, Order 32 Rule 15 Civil Procedure Code provides that a suit must be instituted in his name by a next friend, where the partnership is for a fixed term. The firm is dissolved from the date of judgment, and where the partnership is at will, the firm is dissolved from the date of institution of the suit. And the second ground is that a partner has become permanently incapable of performing his duties as a partner. Permanent incapacity of a partner is a ground for dissolution of a firm by the court. The suit must be brought by any partner other than the one who has become permanently incapable of performing his duties as a partner. Thus, physical disability of a partner resulting from an attack of paralysis is a sufficient ground for dissolution by the court provided that attack is permanent. And the third condition is that a partner is guilty of misconduct which is prejudicial to business. The misconduct referred to is not misconduct towards the partners but towards third parties in the course of the partnership business. Thus, immoral conduct of a medical partner doing the work at a accouchers man's midwife may furnish a sufficient ground for dissolution by the court. And the fourth condition is that a partner willfully or persistently commits breach of agreements or conducts himself in such a way that it is not practicable for the other partners to carry on the business in partnership with him. Casual breach of partnership agreement is not sufficient. There must be intentional and continued breaches, continued neglect to account for the partnership money received or continuous application of sums received on behalf of partnership for one's own purposes may afford good grounds for dissolution. And the fifth ground is that a partner has in any way transferred the whole of his interest in the firm to a third party or has allowed his share to be changed as provided under Order 21 Rule 49 of Civil Procedure Code or has allowed to be sold for recovery of arrears of land revenue or other dues recoverable as arrears of land revenue. And the sixth condition is that the business of a firm cannot be carried on except at loss. The object of partnership is profit, and if there is some inherent defect in the business and it can only be carried out at loss, the very object of partnership is defeated, and therefore the court can dissolve it. And the last seventh ground is that on any other ground which renders it just and equitable. This is residuary clause which enables the court to dissolve a firm on any reasonable ground other than those mentioned in clause 8 to clause F of the section. In this clause 6, relief by way of dissolution. So now we'll go to the last question, that is question number 11 under Partnership Act 1932. Is it open to a partner to sue another for partnership accounts? If so, in what circumstances state them precisely. So, regarding this answer, the general rule is that a partner cannot sue another partner for partnership account during the continuance of the partnership without paying for its dissolution. Ordinarily, a suit for dissolution and accounts or a suit for accounts of dissolved partnership is the only suit which lies between partners. But a suit, however, lie for partial accounts without a prayer for dissolution, whereby the terms of partnership agreement account is to be rendered annually by the managing partners. A suit lies for partial accounts also. And for that, you will see the following three provisions in which a suit for accounts between partners may be brought without asking for a dissolution, and those following three cases are where one partner has sought to withhold from his co-partner the profits arising from some secret transaction, and the second case where the partnership is for a term of years still unexpired, and one partner has sought to exclude or expel his co-partner or to drive him to dissolution. And the third case, that is where the partnership has proved a failure and the partners are too numerous to be made parties to the action. So, the very suit for accounts may be brought without praying for dissolution, where special circumstances so require. So, these 11 questions, as we have selected from the very provisions of Partnership Act 1932, are important selected questions, and these questions will be helpful to those students who are appearing either 3-year or 5-year LLB examination or any examination pertaining to business law or commercial law. And in our upcoming video, we'll discuss Negotiable Instrument Act 1881, and regarding that also we have selected a number of questions which are relevant in connection to the very syllabus of Negotiable Instrument Act of 1881, and particularly those which relevant and important provisions, and usually those questions which are asked in different examinations concerning 3-year or 5-year LLB or regarding any business law or commercial law papers. So, we have selected only those important relevant provisions from which we made all these questions relating to either Sale of Goods Act or Partnership Act or Negotiable Instrument Act. And as we have already finished the very law of contract, and in those portions we dealt with certain important questions relating to contract of indemnity, contract of guarantee, discharge of surety, contract of bailment, and contract of agency. So, in our upcoming video, we'll discuss negotiable instruments.